Good afternoon, everyone, and welcome to today's session on commercial conveyancing with Avista Solicitors. So we will be discussing mainly the uh, everyday issues we face when we do commercial conveyancing for a client. So for that discussion, we have got today Mr. Shashant Shah, Principal Solicitor, as well as Barrister and Director of Avista Solicitors. Mr. Shah, welcome to today's discussion.
Thank you for having me. Hope you are coping well with the hot weather.
I have you as well. So uh, you are a convincing superstar. So what type of commercial convincing you usually do?
Usually, commercial conveyancing is a vast chapter. We mainly cover the business, selling the business, as well as occupying the lease from the landlord. When you
Mhm,
act for the landlord, so granting the lease for the tenant. These are the, as you know, that the lease in this country is a legal agreement between the two parties,
mhm,
between the landlord and the tenant. So both parties need to know each and everything, the terms and conditions, mainly their rights and liabilities.
mhm. So yes, sometimes we see that clients come to us and say that we need to sign this list quickly, very quickly. We don't need to know any terms. What do you tell in that circumstance to the clients?
In these circumstances, as you have seen many occasions, we always discourage that without reading and knowing the contents of the lease, which is a
Hmm.
legal agreement between the two parties, you don't know what rights and what liabilities is on your shoulders. So please don't sign, and I will not be simply the witness. Just hello, can you hear me?
Yes, I can hear you now.
So without knowing the contents of the lease, we never gonna be the witness of the agreement.
All right. So, yes, we have got a recent case on commercial matter, a dilapidation claim.
Mhm.
So we have seen that when I was reviewing the lease, that I've seen the repair clause was like really difficult for the tenant.
Mhm.
So why do you think that that happened? Why do you think that the client has to suffer at the end of the lease term?
It's very common, Joydev. You know,
Hmm.
landlord, whoever acting for the landlord, it is their best interest to look after their client's interest.
Hmm.
And our client, unfortunately, was not, you know, uh, I would say, not informed by his solicitor properly in respect of the repair obligations. That's why
Hmm.
he was not fully aware of it. And at the end of the tenure of the lease, when the landlord issued a big dilapidation claims, and then only he came and seek our advice.
Hmm.
We feel sorry in this scenario, but if he would have been our client from the beginning, then scenario would have been different.
Definitely. So when you're talking about repair obligation, what do you usually face when you draft a lease as a
When, when,
landlord
when
from the landlord's perspective as well as the tenant's perspective?
okay, landlord, end of the day, nowadays is a common that FRI, fully repairing an insured lease,
Hmm.
they will not be responsible for any cost whatsoever in the premises. Even I have seen to some extent that the landlord expect, they are giving us clear instruction that make sure that even there is any structural damage, I will not be responsible during the fixed period of tenure. So it is
Hmm.
the tenant's responsibility. So it goes straight away to the tenants. We prepare the documents in such a way, so it is the tenant's responsibility during the tenure of the lease.
Hmm.
Alternatively, when we act for the tenant if the agreement between the two parties that structural cost will never be uh, or will never be responsible by the tenant, then we accordingly go back to the landlord and request to amend the lease accordingly to make sure that our client is not responsible for paying the structural any defect in the premises.
Hmm. All right. So I want to touch another important point in this regard. If you remember that few days ago, we completed a lease where there was no schedule of condition, but then we explained it to the client that what is a schedule of condition, and
Mhm.
after understanding and getting knowing to it, he agreed that we should have a schedule of condition attached to the lease, and afterwards the landlord and the tenant both shared their portion of cost and completed that schedule of condition. If you can explain for our viewers what is a schedule of condition and how it can protect both the landlords and the tenants' interest at the end of the day, I believe that would be a really good idea and good thing for
is
the viewers.
is very very important point for both parties to understand why it is necessary. Schedule
Hmm.
of condition usually prepared by a designated third party
Hmm.
who has nothing to do with the landlord or tenant or to look after their best interest. They are fair and reasonable. Whatever is the present condition before entering into the agreement, they prepare the as it is. Okay.
Hmm.
From the landlord point of view, landlord will expect that after the tenure of the lease, you will give me the premises back as it is.
Okay,
Similar way, tenant is also protected. If there is a schedule of you know schedule is there, landlord cannot demand anything more than what is the current status of the premises. They
definitely.
cannot expect that you spend more money when you leave the premises and make it more beautiful, or spend more money to make it amenity beauty. They cannot expect anything like that.
Hmm.
It has to be whatever at the current stage. Landlord cannot expect anything more than that. Tenant doesn't have to bear the cost of anything more than whatever he has received.
Yes, I got it. I mean, if I mean the case we were talking about the dilapidation claim, as you can remember, there was no schedule of conditions, so we do not know exactly what was the condition and how far it has been deteriorated. So this
Exactly.
is something, yeah, it's a disputed fact now. We don't know what's going to happen in the court. So yeah, that's a quite important point. Do you think that the solicitor should, I mean, solicitor should, or should I say that solicitor has a duty to explain these things to a layperson who is his
Of course,
client?
of course, of course. You initially asked me a question when the tenant asking, "Oh, I got the right place. My fund is ready. Terms
Hmm.
and conditions all are agreed. Can you please finish the lease within a week, within a month?"
Hmm.
Lots of solicitors I have seen, they do it in a so quickest way. Even they don't properly advise to their client what is necessary.
Okay, I think there is a bit of technological issue. Anyway, what we are discussing about schedule of condition, it is really important for both the clients as well as, I mean, the tenants as well as the landlord to have a schedule of condition to protect the interest, definitely. So that is one very important point he has raised and discussed. And so let's see if we can connect us in a moment. All that I don't see him coming back. So I think he's in now. I can't see him. Anyway, these are the two main topics we wanted to discuss today: dilapidation and repair application, and how it can be countered properly and apportioned between the landlord and the tenant. So there is no future dispute when the lease terms at the ends. So I believe it's not coming back anytime soon. Anyway, in that case, I will finish our program today and probably in our next session. Let's see. It's not back again. No. So set for another 30 seconds. All right, he's not in. Probably the heat took the, I mean, even the network got the impression of the heat. So yeah, we're going to finish it today. Our next session, we will be discussing about the security of tenancy, assignment, and transfer of existing lease to another tenant, and how it can take place. And also, we'll be touching some other areas, for example, rent reviews, servitures, and how it is actually calculated. Break clauses, that is another important area. So hopefully we'll see you next week. And if you have any queries, definitely you can raise it following the link, as well as if you have got any question regarding any commercial leases, then you can contact us via the email ID or the phone number provided at the bottom of this stream. And also you can find us at Google by searching just Avista Solicitors, and you will get everything from there. So thank you for being with us today. Hopefully